You know, when you live in a community with a homeowners association, you agree to a certain set of rules. But what happens when the very people in charge get accused of breaking the biggest rule of all? We're about to dig into a legal battle where control of community property and millions of dollars in value all came down to the definition of a single powerful word.
So it really all boils down to this one huge question. Can your HOA board just sign a deal that gives a private company exclusive control over your community clubhouse without you ever getting a say?
Okay, so let's set the scene. We're at the Peaks Vista community in Fountain Hills, Arizona. And the star of our show is the community clubhouse. It's what's called a common element, which just means it's owned by every single resident. You know, the kind of space that's supposed to be for everyone. But, as you can probably guess, one decision by the board was about to throw all of that into question. All right, so let's meet the key players in this dispute. On one side, we have the petitioner, a homeowner named Susannah Sabnekar. And on the other side, the respondent, the Peaks Vista Owners Association, basically the HOA board. Yeah, it's the classic showdown. One homeowner against the entire board. So here's the spark that lit the whole fuse. The board voted to give a developer, a company called Rockwell, exclusive use of a big chunk of the clubhouse to use as its own private office. But get this, and this is a pretty big detail, 4 of the board members who voted yes on this deal were also employees of that same developer, Rockwell. So for one homeowner, this wasn't just a simple mistake. It felt like a massive conflict of interest. So, you might be asking, how does one single homeowner even begin to challenge their entire board? Well, in this case, she came armed with her reading of Arizona state law. Right from the get-go, in her opening statement, Susannah Sabnekar laid her argument out plain and simple. She said that state law requires a massive 80% vote from all the homeowners to convey a common area, and because the board just approved this motion on their own, they acted illegally. And this brings us to the one word that this entire case hangs on: conveyance. Sabnekar's whole argument was that giving the developer this exclusive space wasn't just lending it to them. It was a conveyance, basically a permanent handover of property that belongs to the community. And if she was right, the board had no power to do it without that homeowner vote. So, just to break down her argument, it's pretty straightforward. Point 1, the clubhouse belongs to everyone, all 212 homeowners. Point 2, what the board did was a conveyance of that property. Point 3, state law says any conveyance needs an 80% vote. And point 4, the board didn't get that vote, which makes their decision illegal. You can see the logic, right? It's a pretty clean, step-by-step argument. Okay, so that's the homeowner side. How in the world did the HOA defend this? Well, what's fascinating is they didn't really deny the facts. Instead, they argued about the name for what they did. And that brings us to the core of the whole disagreement. The HOA's defense came down to one single but crucial distinction. See, they argued this wasn't a conveyance, a permanent sale of property that would need that huge homeowner vote. No, they said it was just a lease, a temporary rental, something the board could totally approve on its own. The entire case, really, was going to be decided on which of these two words best fit the situation. So the HOA's legal team pointed to a completely different section of the law, the Arizona Condominium Act. And they said, look, right here, it says boards can lease out common areas. They argued that this power to lease is totally separate from the rules about conveyances, and that they were operating well within their rights. But then things got really interesting. The hearing took a pretty dramatic turn. A witness for the homeowner, who was actually a board member herself, took the stand and dropped a bombshell. She testified that a previous board had already looked into this exact same issue and that their lawyer told them the complete opposite, that the board did not have the right to give the developer that office space. Well, you can imagine what happened next. The HOA's lawyer was on their feet in a second, shouting, "Objection!" claiming this was all covered by attorney-client privilege. I mean, it was a super tense moment, and it looked like this huge piece of evidence might get thrown out. But nope, the judge overruled it. The testimony was in, which meant the judge now had to weigh the fact that the board knew, or at least had been told before, that this might not be legal.
So, okay, you've got two totally different legal arguments, a little bit of courtroom drama. How did the judge make sense of all this? What was the final call?
And the verdict was petition dismissed. The judge sided with the HOA. Yep, Susannah Sabnekar's case was thrown out and the board's decision stood. And the judge's reasoning was actually super clear. The law that Sabnekar was relying on, the one needing that 80% vote, it only applies to a conveyance. It says nothing about a lease. In the eyes of the law, they are two completely different things. Basically, the judge looked at the deal and said, hey, this isn't a permanent transfer of ownership, it's temporary. That makes it a lease, not a conveyance. And because it was a lease, the board was perfectly within its rights to approve it on their own, no homeowner vote required. That one word, conveyance, was literally everything. So you might be thinking, okay, that's an interesting story from Arizona, but why does it matter to me? Well, because this whole thing is a huge lesson for anyone who lives in an HOA about just how much a single word in a legal document can matter. So let's break down the big takeaways here, the stuff you really need to remember. First off, a lease is not a conveyance. I mean, they sound similar, but legally they are worlds apart. And that difference gives your HOA board wildly different powers. Think about it. This distinction could mean your board has the power to lease out your community pool to some summer camp for 3 months, and you might not get a vote. That's why the exact wording in your community's governing documents is so important. Knowing these definitions is the only way you can really understand what your board can and can't do and what your rights truly are. And all of this brings us to one final, really important question for you. This case was decided based on Arizona state law, sure, but every community has its own set of rules. So after seeing how the control of a huge community asset came down to just one word, are you really sure you know what your own governing documents allow your board to do? It's probably worth checking. You might be very surprised.